So a warm welcome to everyone for joining today's launch of the publication UNCITRAL Fiddles While Countries Burn, which is a joint publication by Third World Network and the Geneva office of the Friedrich-Ebert-Stiftung, which I'm representing. My name is Yvonne Bartmann, and I'm going to moderate today's event. For those of you who do not know the Friedrich-Ebert-Stiftung, easier to pronounce with the abbreviation FES, we are a German political foundation committed to social democracy and holding offices in more than 100 countries worldwide, most of them in developing countries. We have a very close relationship to the labor movement, and the library of our foundation is one of the largest research libraries in the field of the history and present of German and international labor movement. As a Geneva office, we are working mainly in the area of trade, human rights, social and migration policy. And in whatever we do or we are engaged in, the focus on the global south is key. And this is exactly why the publication we are launching today is of the utmost importance. The Investor-State Dispute Settlement, ISDS, reached headlines a few years ago, for example, when Philip Morris brought an ISDS case against Australia and Vattenfall sued Germany. And with this attention, a wider public started to question an old system which needs reform desperately. The many cases private companies bring against developing countries still today are getting much less attention. However, 5 years ago, a process at the rather unknown UN organization, UNCITRAL, started with the aim of reforming ISDS. This process, as the two authors of this publication delineating in great detail, is rather questionable. Questionable in many ways, but certainly with regard to two basic principles of international processes, especially at the UN level, which are transparency and inclusiveness. Kinder Mohamadieh, who is senior researcher at TWN in Geneva, and Jane Kelsey, professor at the law faculty of the University of Auckland in New Zealand, shed light on this process, which takes place in shadow. And after having read this publication, you may want to agree with me that this may be no accident. Today's event is structured in the following way. First, Jane and Kinder are going to present the key findings of their analysis and policy recommendations for the way forward. After their presentations, we are having 3 experts who are going to comment on the publication. Kekelezo Mashigo, who is Director, Legal, International Trade and Investment, Trade Negotiations Unit at the International Trade and Economic Development Division of South Africa's Department of Trade and Industry. She's South Africa's delegate following Working Group 3 at UNCITRAL. Gus van Gaten, who is Associate Dean and Professor of Law at the Osgoode Hall Law School at the University of Toronto, Canada, where he teaches inter-area international investment law, and Liz Johnson from the Columbia Center on Sustainable Investment, where she's leading the center's work on investment law and policy. I thank you all very much indeed for taking time for joining us today. Thank you is the word before I'm going to hand over to Chi Yok Ling, the Director of Programs at TWN, who will give some welcoming remarks before Kinder and Jane will start with her presentations. I hope you allow me, and actually you don't have a choice since I'm the moderator, to take a few more seconds to thank a number of people who have been involved in this publication and in setting up today's event. I sincerely thank Kinder and Jane for the passionate and meticulous work to analyze the current process of the Working Group 3 at UNCITRAL. And I hope that many people will not only read the introduction and conclusion, but the entire publication. Each page was an eye-opener to me. Thank you also to the 2 reviewers of the paper, Liz Johnson and Cecilia Olive. I thank Yvonne Miller and all TWN colleagues and friends who have been involved in this project. I'm also thanking my own colleagues for their hard work, especially Corinna at FES Geneva and Christiane at FES Berlin. And last but not least, I would like to thank my director, Hajo Lanz, and Kinder's boss, Yok Ling from TWN for having given us their go-ahead for this publication. Without further ado, I'm now handing over to you, Yok Ling.
Thank you very much, Yvonne. Good day from Malaysia. I'm Yok Ling. I'm the Executive Director of Third World Network, and I'm very happy that we are able to collaborate with FES to launch this really important publication. For us in Third World Network, we are a policy research and advocacy organization rooted in the South, started by the Southern Civil Society leadership that always recognize while we try to change national policies, influence how we in the South would need to have the policy space to shape our development choices. Very often, our choices are very much constrained by international norms and agreements. And a lot of the structural and systemic inequities that lie in the area of trade and investment in particular really do need a lot of not just reform, but really fundamental rethinking. And I think in light of COVID-19, this pandemic has really sharpened and not brought anything new, but really proven a lot of what we have as civil society, academia, and many member states have been really trying to bring forth in the discussions, especially in the economic governance and economic norm setting in the last 30 years. So for us, we see in the last few years, the increase in ISDS cases because trade agreements and bilateral investment agreements have actually introduced ISDS in an unprecedented scale. For us, really one of the more recent cases that brought home the irony and the threat to national autonomy and people's welfare is when Pakistan was actually successfully sued for almost to pay $5.9 billion in compensation over one case. The same country that just not so long ago had actually had an IMF loan of about $6 billion. When we contrast those numbers, an IMF loan with its own conditionalities and its own issues and challenges, and in one case, a country is supposed to pay $5.9 billion. And even as we speak, in the light of the kind of measures that countries need to take, we see already Chile has been brought into an ISDS case over a cancellation of an infrastructure project that they really did not need, especially in the context of COVID-19. So there is no mercy in the relentless pursuit of the rights of the private investor. And that is why when we looked at what UNCITRAL has been doing, it has been really a process that we are very pleased. Jane and Kinder, they are part of a very small group of researchers, academia, civil society, looking and following, tracking it something that appears to be so technical for most people, but which really needs a lot of attention in terms of research, understanding, supporting our delegations, especially from the South, in being able to navigate what is being put on the table. For us, it is not just about tinkering with the system. As the title of this study very aptly calls, UNCITRAL Fiddles while countries burn. We are talking about a fundamental re-questioning of even the concept of ISDS. And so it's not a matter of making it more transparent or more inclusive. Where is the developmental aspect? And this publication shows when you actually look at ISDS and what UNCITRAL is trying to do through the lens of development and through the lens of the rights of peoples and nations, then we are talking about something entirely different. So we support very much the Southern delegations in G77 in individual member states to try and actually bring these concerns onto the table. So we believe very strongly this publication, which is not an academic publication, but a publication that brings forth analysis based on actual realities of our countries. And as Yvonne said, ISDS threatens all nation states. But in the South, it has deeper implications, which for us is a priority to bring forth to the public domain. We need people to understand that what's happening in UNCITRAL is something that has to be publicly accountable. So I thank you, our colleagues in FES, for putting this whole publication together. And I really do thank, more than anybody else, Jane and Kinder for just not the 5 years in following this working group 3, but in all the years of actually, tracking how investment rights, investors' rights have actually mutated, just like the COVID-19 virus is mutated, it's become very lethal. And so there's no vaccine against, the wrong kind of investors' rights. And so for us, it really is about prevention. And prevention means public scrutiny. So thank you very much. And I'm really delighted to see this panel of commentators who are going to bring not just perspectives, but real life experiences and urgency to be able to address some of these issues as representatives of their own countries. So thank you very much again to our colleagues in FES and to the authors and commentators. This is something for us, a very crucial thing and very timely. So I look forward to the discussions. Thank you.
Thank you very much. With this, I kick off and ask Jane to start her presentation.
Oh, thank you very much. And good evening, kia ora from New Zealand. Good morning to all of you in other parts of the world. I want to start a bit where Yvonne started, to remind ourselves of the context in which the UNCITRAL process began. Because of course, in the last 20 years especially, we have seen a real crisis of legitimacy, not just in investor-state dispute settlement, but in the international investment regime as a whole. And that's involved renunciation of agreements, withdrawal from the ICSID organization that has been the primary forum for arbitral disputes, development of domestic substitutes in South Africa and Brazil, new, more progressive models of investment agreements, my own country saying no investor-state dispute settlement in future agreements. And for quite some time, it was UNCTAD that led that process from a development perspective, and quite critically. And so when we saw UNCITRAL come onto the scene of ISDS reform, it was initially quite worrying because it has a particular institutional interest as part of the broader arbitral system. And as a lawmaking entity, UNCITRAL has historically been dominated by countries from the global north, a very strong role for private interests, including for arbitrators, whereas governments from the global south have not traditionally been very active. And so there was initially a recognition that this was potentially an attractive forum for the European Union in particular, which was trying to steer reform in the direction of having a two-tiered multilateral investment court. But it was not going to be a comfortable choice for developing countries. When in July 2017, the Commission set the mandate for Working Group 3 to look at reform of investor-state dispute settlement, it approached it from quite a broad base, and the discussions acknowledged all the current criticisms about the investment law regime, concerns about democratic accountability and legitimacy being impugned by the investment agreements and ISDS, and the need for reforms to restore confidence in the overall international investment system. When the mandate itself was being discovered, there were calls from the floor for a wide range of issues and possible solutions to be viewed. But there was a sense that came through that it was going to be much easier to focus on procedures than it was to focus on substance, which would be more complex and more controversial. And so whilst Working Group 3 had a broad discretion to discharge its mandate, the way it was interpreted, and especially over time, the way that the chair and the secretariat steered it, became extremely narrow. Narrow, not just narrowed to procedural reforms, but to a small subset of procedural matters. And many of the issues that were raised by developing countries who insisted that the substance procedure dichotomy was false because the two of them were necessarily intertwined. But even the issues of procedure that they tried to put on the table were excluded or marginalized. And when we looked right at the beginning of the UNCITRAL Working Group 3 process, we could see that it was already being framed by an initial paper that was produced by Gabriel Kaufmann-Kohler and Michele Potesta, who are academics come participants in the arbitration system itself, and that that was very much geared towards promoting a multilateral instrument and appellate mechanism that would not go down the path of the more significant reforms that were being called for, not only by developing countries, but from outside critics, critical academics and civil society as well. And that this process soon became influenced even more by the establishment of an academic forum, a large number of whose members were arbitrator come academics. And so it was not a very friendly institutional environment to start with. Now, in our report, we examined 3 stages through which Working Group 3 has proceeded with the mandate. Stage 1 was to identify and consider concerns about ISDS. Phase 2 then was whether reform was desirable in light of the phase 1 discussions. And the focus then came down to 3 quite specific categories: the consistency, predictability, and correctness of arbitral decisions, arbitrators and decision makers, their appointment, their conflicts of interest, and so on, the cost of duration of cases, and then a 4th quite specific issue of third-party funding was introduced. So now we had, from the broader discussion, a honing down into quite specific issues. And I think Kinder will be talking a bit more about the development issues that were squeezed out of that process. But just briefly to mention some of the concerns that developing countries raised: the need for preventing disputes, alternative forums for resolving disputes instead of arbitration, the role of national courts, the exhaustion of local remedies, the participation not only of third parties, but of affected communities, counterclaims, investors' obligations, the calculation of damages, including interest and future profits, and the broader question of regulatory chill associated with the regime. And the problem in phase 2 was that these got relegated to a category called other issues. And it was almost impossible to get those on the agenda and to get any time allocated to them, which meant by the time we got to phase 3 of solutions, it was solutions to a narrow definition of problems and therefore a narrow menu of potential solutions. There was, for this phase 3 process, a work plan that was developed by the chair and the secretariat, which was largely framed by the developed countries, who are, of course, the capital exporting countries. And it was quite heavily debated, but debated in particular because it had identified 8 streams of work, which were again all dominated by capital exporters' priorities, including the EU's preference for a multilateral investment court or an appellate mechanism. And developing countries' concerns were not only still treated as peripheral, but they were grouped together into a single catch-all that was given relatively little time, especially as they hadn't been discussed to date. Now, this work plan formed the basis of the request to the Commission for more resources recently, and that was the subject again to intense debate. What emerged from there was at least a promise to some kind of ongoing oversight, but very limited. Meanwhile, the implementation of this work plan is proceeding, including informal meetings. And informal meetings have a real problem about who is calling them, who is setting the agenda, what the resources are that's available, especially if some of them look at delving into the drafting of text. And then we have, of course, all of the added problems of participation in the context of COVID-19. There was recently an intersessional that was hosted by South Korea, but the concerns, the other issues that developing countries had raised was in the final session on the final day. So where we are now in this phase 3 and why the report has sought to bring these concerns to the fore is that UNCITRAL and Working Group 3 need to produce an outcome. And they're aiming to do that now by 2026. There are widely differing positions in Working Group 3, even among the capital exporters. Using some categories that the Australian academic Anthea Roberts has used, there are what you might call incrementalists. Russia, Japan, Chile, Israel, among others, who want to pick the low-hanging fruit, the easy ones in this procedural framework, and engage in what they call modernization, basically based on the Trans-Pacific Partnership Agreement, and leave it at that. Then there are the more systemic reformers, the EU, Switzerland, Canada, Mauritius, who are pushing for this institutionalized global investment court, which doesn't change the rules, but provides some more institutionalized, harmonious processes in a two-level system of dispute settlement. And China actually has also supported that idea of an appellate mechanism, but not in a multilateral regime. And so this group don't want piecemeal reforms because they're concerned they will lose their leverage to secure their broader systemic outcomes. US position in this, very unclear. So how do they think they're going to pull together a consensus in the framework of Working Group 3 if the capital exporters can't even agree amongst themselves? Well, the one thing they want to make sure they don't have to do is to amend individual agreements. But they also need to get buy-in from these different groupings. So one way that was looked at to avoid amending individual agreements was to use a process UNCITRAL had already used, known as the Mauritius Convention, where transparency rules that had already been adopted in UNCITRAL would be applied to existing treaties without having to amend them one by one. But there's a lesson from that. Even on the simple issue of transparency, which had already been agreed on, only 23 states signed the Mauritius Convention and only 7 have ratified it. The more favored option, though, is a bit more complicated. And it moves very much towards the lowest common denominator of what a new instrument might look like. It's based on the multilateral tax instrument developed in the OECD to implement the Base Erosion and Profit Shifting, or BEPS, treaty developed there. This MLI, as it's known, is basically a capital exporting country deal. What it would do is amend 3,000 existing double tax treaties. So you can see the parallel to bilateral investment treaties. But it's very much a pick and mix agreement. And it too is based on an already agreed set of rules. Now, in that agreement, there were some core rules that all countries had to adopt, and then they could choose with a whole range of variations, how much of the other provisions they adopted. The US, someone needs to mute. The US actually refused to sign it, so a key player was missing. Many other states took major reservations on aspects they didn't like. So we can see already that this open or variable architecture, if we apply it to investor-state dispute settlement and reform of existing bilateral investment treaties or future ones, there may be some minimum standards, but those are likely to be, if they're going to be agreed, based on the TPP or EU's FTAs. And then there'll be a menu of options that participating states can use. Some may choose not to ratify it at all, including the US. Some will choose the minimal options. Others may choose the systemic change, and the EU can say, oh, we got the MIC, even if a few countries only sign up to it. And only very few will sign up to it all. So UNCITRAL will be able to say, we have a success, we have an instrument. But the result will be different rules across different bids, and developing countries will be the rule takers set by the developed country capital exporters. Most of their demands that may appear in the multilateral investment agreement, the MLI, the multilateral ISDS agreement, is going to be marginal and voluntary. So the system that will be produced through this will be arguably even more fragmented, inconsistent, and costly for developing countries than the current one. And it won't deal with the main procedural issues of concern, let alone the issues of substance. And my concluding concern, which we set out in the report, is that the dysfunctional and inequitable system of international investment agreements and ISDS will have been reformed, but it actually will have been consolidated and re-legitimized that will make the real reform that's necessary even harder, unless we can turn Working Group 3 around. And that's what the report has some recommendations to do. And I will hand over to Kinder to pick up from there.
Great. Thanks a lot, Jane. So as you heard from Jane, the idea of the paper was to kind of tell the story of what happened thus far at Working Group 3 from the developing country perspective, and also more broadly from the civil society point of view and their concerns in regards to reforming international investment governance. And the paper really puts forward kind of a call for attention, if not a call for action, vis-a-vis what is happening at UNCITRAL and its the potential implications of the outcomes on the process of reforming international investment governance. And as explained by Jane, we are at a crunch point, basically, in regard to the process of Working Group 3, which is now planned to end by around 2026. So, so we are kind of halfway through. And while it is a UN process or a process under the umbrella of the UN, I would like to underline what Jane has said, that the approach is not aligned with the what we expect the process to be, which is we expect it to be aligned with the overarching agenda of the UN, at least the sustainable development goals and the human rights obligations. And as Jane said as well, it's been really frustrating to see that the role of other UN agencies, which traditionally have worked a lot on the reform of international investment governance, like UNCTAD, has been marginalized in this process. So to kind of underline why we dedicate so much importance to this process, I want to re-emphasize what Jane have highlighted, that if the outcome of the UNCITRAL Working Group 3 process is positioned as, in the end, as offering a coherent solution to the current deficiencies of the ISDS regime, while being limited to dealing with these limited set of procedural issues, then it will be much harder for developing countries that want to do better and more systemic reforms, and for civil society who have been campaigning and advocating for systemic reforms in the system, to push forward that process. And we will end up with a minor agenda of tweaking the system in order to restabilize it and re-legitimize it, and in effect close the door for more substantive, meaningful reform in the coming period. Now, if we look back at the beginnings of the process, developing countries and civil society groups who follow this process closely, and their number is not really big, you can count them maybe on one hand or like on the two hands, they have been articulating the issues of reform of ISDS with a sustainable development point of view. So many developing countries sought to anchor the ideas they put forward for ISDS reform in this broader sustainable development objectives. They basically spoke about 4 very important issues in multiple meetings at the beginning. One is the attention to the right to regulate and the ability to protect the legitimate public welfare objectives. Second, that promoting and attracting investment should not be the end, and that it should contribute to the broader objectives of sustainable development and human rights. Third, that true alternatives to arbitrations must be considered by Working Group 3, and the role of mechanisms like arbitration should not lead to marginalizing other procedures and institutions like domestic courts. And fourth, a lot of developing countries and civil society spoke about the importance of addressing rights and responsibilities, the balance of rights and responsibilities of foreign investors, and linking the access to dispute settlement to the conduct of investors and therefore the fulfillment of their obligations, wherever they arise from, whether domestic law or treaties, or maybe in the future from international law. So the developing countries have articulated and anchored their demands and positions in sustainable development. And as Jane have mentioned, they have put forward, and it was an uphill battle to put forward the list of issues that ended up to be considered as cross-cutting issues on the table. Maybe I'll share a screen and I'll just put these lists on the, I don't know if you can see my screen. You can see it?
Yes.
Yes.
Great. So these are the list of issues, means other than arbitration to resolve the investment disputes, the role of domestic courts, including exhaustion of local remedies, third-party and affected communities' participation, the counterclaims and the linkages to investor obligations, damages, and regulatory chill. These were the list of issues that developing countries have, a number of developing countries have fought hard to put on the agenda, and they were recognized in the 37th meeting of the working group, which happened in New York in April 2019, as issues that the working group considers important and will be looked at and addressed in the process of negotiations and continuing the discussions. But up until now, none of these issues have been meaningfully addressed and dedicated the needed time and resources meaning being put on the agenda, but also being given the enough attention in terms of preparing background analytic notes by the Secretariat, by the UNCITRAL Secretariat on these issues in order to allow for the members to deal with these issues in the formal meetings. Because if you're not familiar with UNCITRAL, usually the discussions happen based on working documents that the Secretariat prepares and the members address and discuss them. So we can see that up until now, developing countries have invested major negotiation capital to an effort in order to highlight these issues and put them on the agenda, but have not been able to really arrive at addressing them meaningfully. But as Jane mentioned, in the beginning of this year, we have seen a major pushback by several developing countries in two important meetings that happened early in May and in July. The first meeting was a formal meeting of the working group that addressed its work plan for the upcoming period. And the second was a meeting of the Commission, which addressed, and the Commission, which is basically the members, the UN member states sitting as UNCITRAL.
Very sorry to interrupt. I thought first it's only me, but we see only half of your screen.
Oh, sorry.
I don't know. Now it's better. Thank you.
Anyways, I can stop sharing so it doesn't annoy you. So in the Commission meeting, there was a major pushback from a number of developing countries in order to link the request by the working group for additional resources in order to intensify its work from now until 2026 to a revision of the work plan in order to adequately address the issues that developing countries have put forward. And maybe Keki will tell us more about this because she was a lead in terms of this request and the ability to link these two issues together, the request for resources and addressing the developing countries' issues. So now we have kind of resurrected these issues on the agenda, but still everything depends on the modalities of handling the process in the future, including how meetings are going to organize, how agendas are going to be identified, how time is going to be allocated, and whether meaningful analytic papers are going to be presented in the working group in order to allow for negotiations on these issues. But so in general, we can see that at this point, which is basically halfway till the end, we have the working group still focusing on issues that will not really rock the boat, such as selection and appointment of investment tribunal members, code of conduct for the tribunal members, advisory center to support in claims, mediation as a pre-stage to arbitration, appeal, and the multilateral investment court, as Jane have explained. All of these basically, they do not really change the fundamentals of and the basic systemic problems of the system, which is that it is an exclusive system for investors to initiate disputes, that it marginalizes domestic systems and domestic courts, that it allows a challenge of any measure and regulation, including non-discriminatory regulations in the public interest, that it marginalizes the space or the ability of those impacted whose rights are impacted by these claims to have any say in these claims, such as impacted communities, local governments, and other parties. So we see that we're still not really, everything we're addressing would potentially reposition ISDS based on arbitration as the system for dealing with investment disputes, but will not really open the system for real re-evaluation and rethinking. So this is why in the upcoming period, it is important to focus on a few important kind of changes that needs to be seen. One, it is important to kind of position the UNCITRAL, whatever comes out of the UNCITRAL process, as a very minor addition to whatever has been done so far and should be done in the future in terms of reforming international investment governance. Because there is a real fear that whenever UNCTAD declares that it has an outcome and it's a multilateral outcome, that this would come to be seen as the answer to what needs to be changed in international investment governance, and that as long as we have these changes in terms of the procedural aspects of these international investment agreements, or that we can continue with the system as is, which would end up basically marginalizing the whole movement to change the substantive content of these agreements. So basically the standards of protection available to investors under these agreements, and will also marginalize the ability to more fundamentally and systemically reform the dispute settlement system. So this is one of the important tasks we have in front of us. And this is something that ought to be of high importance for not only developing countries, but also civil society organizations that have been campaigning for years and years in regards to reform of international investment governance. When it comes to Working Group 3 specifically, it is important to call for reopening of the agenda to allow developing countries to elevate their concerns and the reform priorities that they have been pushing for to a priority in the next meetings. It is not enough to keep on telling developing countries, well, we hear you and we understand these important issues, but our agenda is very flexible. This is the mode in Working Group 3. Whenever developing countries stand up, the chair tells them, well, we have a flexible working plan. We will address these in the future. And the fear is this, that the flexibility is gonna come to be a determining factor in terms and a detrimental to the interest of developing countries, because their demands keep on being rolled into the future under the claim that we are flexible in the work plan of this working group until we don't have time anymore in 2025 or 2026. So this is a major challenge in the upcoming period. And on top of that, we really need to see a process to audit the work of Working Group 3 from a more macro developmental lens that takes into consideration how whatever Working Group 3 is dealing with aligns with the broader sustainable development and human rights considerations that are on the agenda of the UN member states. And for those purposes, it is important to call as well for linking whatever comes out from the UNCITRAL Working Group 3 to what other parts of the UN system are doing as well in terms of addressing investment and investor obligations, such as, for example, the work of UNCTAD, the work on the legally binding instrument on business and human rights, and other work in this area. And for that to happen, we need to call on the member states to activate their role, sitting as the commission, which is supposed to monitor and oversee what comes out of Working Group 3, and also sitting as the General Assembly in New York, which will receive the final outcome of Working Group 3, in order to keep a monitoring eye and allow for potentially kind of readjusting the trajectory of travel of this working group. Thanks a lot.
Yeah, thank you both very much, Jane and Kinder, for the presentation of the content of the publication. I think Jane has delineated and described very well how narrow the approach has been, is at the Working Group 3, and Kinder pointed out the development aspects and how difficult it has been so far for developing countries to broaden the process at Working Group 3. And I think most of you will agree, it looks a little bit that at UNCITRAL currently one tries to put a little bit of color on a house which is almost falling apart, instead of really talking about how to reconstruct it on a better basis. I'm now inviting Keke from South Africa to take the floor and to give some comments. Who is representing South Africa at the Working Group 3 at UNCITRAL? Keke, the floor is yours.
Thank you very much. Good morning, good afternoon, and perhaps good evening to everyone. And thank you very much to the organizers of this event. And thank you very much for inviting me to this event. Thanks especially to Kinder and to Jane for your paper and for your presentation. I think the contents of which I could not agree with more. And I believe the title of the paper is very fitting, given that UNCITRAL is indeed fiddling while countries are burning. UNCITRAL is fiddling, given its approach and limited scope, while countries are burning as they are faced with staggering amounts in compensation damages. I think the sheer amounts that have been awarded are constantly increasing and reaching, in some notable cases, multi-billion figures, some of which amount to approximately 2% of the GDP of some of the countries. And indeed, as your paper highlights, ISDS has become a controversial issue in recent years. And the ongoing legitimacy crisis in ISDS has triggered an attempt at multilateral reform. And the UNCITRAL deliberations are an effort to craft a multilateral process to the mounting frustrations over the current state of the international investment government regime. And I believe that being a participant in the UNCITRAL deliberations, I think it would be remiss of me if I did not comment on the paper by contextualizing the UNCITRAL discussions and highlighting the dynamics at play. This is because context and dynamics matter, as they speak to the political nature of the discussions, the mandate in terms of scope, the vested interests at play, and the likely outcomes. And I'd like to begin with us noting the importance that the UNCITRAL debates on ISDS reform are very political. Firstly, on the international level, countries are split on whether to embrace ISDS, and if so, whether international claims by investors would be better heard by ad hoc arbitral bodies or a permanent investment court. On the other hand, on the domestic level, ISDS has proved highly controversial in a number of countries, resulting in strong pushback. And dealing with such a highly charged issue is not business as usual for UNCITRAL. In addition to this, in terms of representation, the Working Group 3 discussions are government-led with high level of input from governments. Again, this is not what typically happens in UNCITRAL Working Group 3 meetings. Furthermore, in terms of choosing a chair for Working Group 3, the chair had to be voted in instead of conforming to UNCITRAL's typical approach of working by consensus. This is because Working Group 3 could not agree on a chair by consensus. The fact that the issue had to be put to vote is a sign that reform efforts are a highly charged political issue and how contentious the reform process is, as the deliberations have the potential to lead to some sort of multilateral statement about problems with ISDS and recommendations for reform. And this definitely raises the stakes for countries significantly. A second point that I'd like to contextualize is that in terms of mandate, which speaks specifically to the scope. and procedural issues versus substantive issues. At UNCITRAL, the scope for a more radical reform of ISDS, let alone the substantive overhaul of the global investment treaty regime that many voices feel is required, is limited because of the approach that has been adopted in Working Group 3, as well as the continuing dominance of the process by the vested interests in investment arbitration. And although the Commission agreed that broad discretion should be left to Working Group 3 in discharging its mandate, the interpretation of such broad discretion has in fact attracted critique, particularly with respect to the scope of discussions. So Working Group 3 discussions have unfortunately been limited to procedural issues, as highlighted in the paper. Now, some countries have insisted in Working Group 3 that Working Group 3 is solely limited to procedural aspects of dispute resolution. However, other countries, like South Africa, have argued that there is no consensus about substantive treaty reform being excluded from the mandate, and that instead, Working Group 3 was given a broad mandate and discretion and would not be fully discharging its mandate if discussions on the substantive concerns are excluded. In addition, these countries have argued that discussions cannot divorce the procedural from the substantive concerns as they are intricately related. And I tend to agree that ideally ISDS reform should be approached holistically rather than piecemeal, as only systemic reform will allow addressing concerns with ISDS in a comprehensive manner. A third aspect that I'd like to raise is that related to vested interests. UNCITRAL is an institution that's deeply embedded in the ISDS system. So for example, the UNCITRAL arbitration rules are the second most popular rules in investment arbitration. The question now is whose views is UNCITRAL most interested in hearing? In addition, highly problematic is the presence of many practitioners, mostly non-governmental lawyers and academics with experience in ISDS, either as an arbitrator, counsel, or expert witness, and lobby groups in Working Group 3. Several private arbitrators and lawyers are in fact part of the official government delegations that attend Working Group 3 meetings. Furthermore, the majority of the invited non-governmental organizations participating as observers in some of the meetings are in fact directly or indirectly linked to the private arbitration industry, with only a few representing wider public interests. Again, this is highlighted in your paper, and this contradicts the explicit objective of UNCITRAL of achieving a balanced representation of the major viewpoints or interests with regard to ISDS. Equally important is that the arbitration industry is not keen for UNCITRAL to engage in meaningful reform of the system. Those who wish to save the ISDS regime are hijacking the UNCITRAL reform discussion to maintain the status quo or promote half measures around the margins that do not address ISDS's fundamental flaws. So just to wrap up my points, I want to agree with your paper that effective consideration of the developmental implications of ISDS require a broad interpretation of the negotiating mandate and consideration of alternatives to arbitration as a means to settlement of disputes, failing which I believe that Working Group 3 is likely to produce at best a weak compromise between the different perspectives on ISDS. In my view, by foreclosing the discussion about the broader problems with investment protection rights, Working Group 3 is narrowing its future discussion on the full range of solutions. The UNCITRAL process could offer a unique opportunity to thoroughly examine the widely recognized problems with ISDS and to meaningfully address its systemic imbalances. However, the process is to a large extent driven by the same institutions and the same individuals that share a common interest in the long-term survival of the system. I also agree with your paper that the UNCITRAL process runs the risk of producing middle ground solutions that will fail to address the fundamental flaws of the ISDS system and will only further institutionalize and re-legitimize the system. So for me, such an outcome would be very unfortunate at a time when ISDS is losing political will all over the world, and a growing number of countries are signaling a desire to move away from the current model of treaty-based investment protection. I think one last point that I'd like to end with is to state that Now that development of reform options are underway, I think it's important for countries to really reassess the discussions that are taking place in Working Group 3. It's important for countries and stakeholders, and especially developing countries, to fully engage and to make their voices and priorities heard. It behooves these countries no more than ever to engage meaningfully and constructively to determine which solutions best meet their needs. I believe that developing countries need to ensure that they contribute to drawing up a work plan that includes the issues of concern, accompanied by the required time and resources for discussion. And this needs to lead to systemic reform of ISDS rather than isolated fixes of some of the troublesome aspects. If countries do not prepare for and engage in Working Group 3, they risk seeing the hard-fought UNCITRAL process fail to deliver meaningful reform of the existing international regime for investment-related dispute settlement. And I believe that not engaging in reform discussions would come with serious drawbacks, in that it would not address any of the challenges arising from today's global investment regime, and would keep the countries exposed to risks created by international investment agreements in their traditional form. And I thank you, Chair.
Thank you very much, Keke, for your very precise position. Also, thank you especially for your last point. So I hope with also this event and the publication itself, we will achieve to get wider attention throughout, not only, as you said, governmental officials, but also civil society organizations to get engaged in this discussion and to try to rescue whatever we can. I'm now inviting Gus from the University of Toronto from an academic point of view to give his comments, and maybe he could also add a little bit on the approach of having a reform focusing on procedures rather than substance, and how this from an academic point of view can even be separated.
Thank you very much, Yvonne, and good morning, afternoon, and evening to everyone. It's very nice to be addressing you over the Zoom waves today. I very much enjoyed reading the paper that Jane and Kinda wrote. I thought that it was absolutely timely, very rigorous, very focused on, among other things, critiquing the UNCITRAL process, which from early on had signs of flaws, but I take my hat off to you for having done the hard work to actually delve into the details and follow this bureaucratic process to the point that you have. That's the first thing I'd like to say. The second thing I'd like to say is that we have seen reform processes that worked quickly and that were sweeping and fundamental in their impacts in this system. And those reform processes happened in the 1990s, when so many investment treaties were concluded very rapidly with profound potential impacts on states all over the world. I say potential because those reforms were at the time all on paper. They were very quietly being implemented in the decade of the 1990s by a very creative group of arbitrators and lawyers who saw the potential. And in just 10 ISDS cases that were decided against states in the decade of the 1990s, I guess it was just coincidence, but the investor, the claimant, was successful in every one of those first 10 cases. Some were settled, but most were won outright against the state. Some of those cases weren't public at the time. It took years before they became public. From my perspective, having read all those cases, I think all of them were based on dubious interpretations of the treaties that have now become solidified in the jurisprudence of arbitrators, thanks to not 10 ISDS cases in the next decade, but rather hundreds, to the point that we have over 1,000 cases we know of since the year 2000. So reform of international law can happen very quickly. It can happen quietly with very little public attention, and it can have profound implications for hundreds of millions of people all over the world whose interests are diminished as a result of the reforms that are put in place. And what do those previous reforms lead to? Very simply, I would say, and this is my third point, what we have today is called ISDS, it's called other things, investment treaty arbitration, and so on. But at root, the effect of this system is to already have created something like a Supreme Court for the entire world that can review anything that a state does, virtually anything, in its executive role, its legislative role, and even its judicial role, except it's not actually a court, it's arbitrators instead of judges, so it doesn't have an independent judicial membership. It doesn't have a process that is fair because all affected parties can participate. It is not respectful of domestic courts because it rather displaces them. And I think most importantly, its sole purpose is to protect the established wealth of asset owners who can claim to be foreign, in effect, most of those being very large companies and very wealthy individuals, giving them tools in international law to use against states that are just unheard of in other areas of international law. And this brings me to my fourth and last point, returning to the report that Jane and Kinda have provided to us. They've also provided wonderful documentation on some of the newer areas in which ISDS is being deployed in order to frustrate vital governmental action and state action to address not just the needs of their populations, but the lives and basic health of their populations. And here I point especially to the research included in the report on the how ISDS can be used to frustrate climate action by states, and most strikingly, how it can be used to frustrate state action to address the COVID-19 global pandemic. If there were ever a more stark example of the skewed priorities that the existence of ISDS treaties creates, then I think Jane and Kinda have pointed us right to it and provided documentation to support the concern. In my own research, our research on how investment treaties have, some say, created regulatory chill, I like to say have reconfigured the state in favor of a very narrow band of interest at the expense of everyone else. I think that in researching these things, we usually have to look at public awards and very rare public settlements in ISDS cases. But in my own research, based on interviews with people who work in the ISDS, especially government officials responding to claims, and in research on statements that ISDS lawyers make in order to promote their services, I think the examples we have of regulatory chill and state reconfiguration, I'm sure, I think are, well, let me put it in academic terms, I think are very likely to reflect only a small fraction of the number of situations when ISDS is used to deter state action in problematic ways. So I would say on that fourth point, I want to thank Jane and Kinda for bringing that aspect of the discussion so up to date in the context of a bureaucratic reform process that, if I may say, can leave one feeling a little cynical, and point to how possible it is to actually reform this system quickly and widely, and that is by doing the opposite of what was done in the 1990s. Instead of signing all the treaties, unsign the treaties, withdraw from the treaties. It's quite simple. One country can do it by itself. You don't have to worry about all of the bureaucratic ins and outs of reform processes run by an organization with a complicated acronym. Thank you very much for allowing me to comment. I really appreciate connecting with all of you in this way over the Zoom waves in these difficult times for all of us, and keep up the great work.
Thank you very much. Thank you very much for your time and your comments. Liz from the Columbia Center on Sustainable Investment, you've been also one of the reviewers. Is there any hope, or is everything lost? How do you...
Hard question. I also want to thank you for the invitation and the opportunity to hear this discussion and the opportunity to read the paper. And I just wanted to maybe share some thoughts about the paper and what it inspired, reactions it inspired, and then maybe some thoughts about ways forward, which also hope to respond to some of the concerns outlined in the paper. I found reading the paper cathartic. Participating in the UNCITRAL process, which I've done since it began, it's been time intensive and frustrating. And I think with constant questioning about whether or not the costs of participating outweigh the benefits. I've seen the systemic sidelining of concerns, of approaches, and of solutions that are outlined in the paper. I see representatives of public interest observer organizations being disproportionately admonished to stay silent or be brief. I have been told that the process is not open to considerations of policy or political matters, with submissions and papers not being welcome if they are political, which was then defined as calling for dismantling of the system. But papers that called for reform to the system but keeping it would not be deemed political. I've been told also that the work of the working group is merely technical and that there is no time or room for addressing questions of policy. And I think the focus is, as the paper outlines, the focus has been very deliberately on the trees, or even maybe the twigs, I would say, as opposed to the forest, much less the broader ecosystem within the forest, within which the forest sits and affects or is affected by. And I've seen, particularly in recent meetings, the informal and the intersessional meetings in particular, real disengagement by all but a few delegations, such as the EU, the UK, and the US. So that is why I felt the paper does a great job of documenting some of these issues and concerns. Now, I should say that I still, though, and I really appreciated KK's comments, because I do still value the process. And I value the work of the Secretariat and the Chair and the Rapporteur and the contributions of delegations. And I understand the pressure on the Secretariat and the Chair to produce an outcome in this consensus-based process, where when we're working in a field where consensus does not seem to exist. So I think that they are also facing challenges, which presents a challenge to us. And how do we navigate this to try to get something out of this process that is actually meaningful? So this paper is also really helpful for thinking through some of those issues. And I think it's crucial to have now, and I wish we would have started with this type of collective and inclusive conversation about what the system of investment dispute settlement aims to achieve, and how the reforms produced through UNCITRAL can achieve those aims. I also think it's essential, especially since this process is at the UN, to ensure that the processes themselves are consistent with SDGs 16 and 17, and that the outcomes from this process are similarly consistent with those same goals. So I think the paper, it did mention a framework convention that we had proposed in the UNCITRAL process, and maybe if possible, I could outline that just very briefly as a way of potentially suggesting some ways forward, but also responding to some of the concerns about the process. And let me just try and share my screen really quickly, because I think it might help. It might help illustrate what we were proposing. So some colleagues he might still be on, colleagues from Georgetown University, the Harrison Institute of Public Policy, and Corolla, we proposed this framework convention on investment and sustainable development to be discussed in UNCITRAL. And it's not, I mean, it's nothing hard baked, right? It's a proposal that we would like to further discuss and refine and elaborate on and debate. And I think it tries to respond to this quote from the paper, which we're calling for. I don't know that we even need to reopen. I think the working group 3 agenda is already open to this. It's just a matter of, I guess, redirecting current initiatives and efforts. And also to respond to the concerns, not just from the global South, but from kind of all non-investor stakeholder interests to address the system. So the paper, I think the proposal tries to do 5 things. It provides this instrument to implement reforms, but then it will ensure that this instrument provides an opportunity to dock or implement reforms that go beyond a narrow mandate. I think that there's no reason why any reform instrument developed through UNCITRAL needs to further cabin reforms developed under that instrument in the future. And I think there's a real opportunity for using this process to try and harness international cooperation and governance to maximize the benefits of international investment that can flow, but that often do not, and try to avoid some of the harms that too often arise and are not addressed. We do structure this in a way that there is a lot of flexibility, and I entirely sympathize and understand and think that with the concerns raised in the paper about the problems of flexibility. So this is an area I think really needs more attention, is how do you structure flexibility to make sure that it doesn't create undue complexity and doesn't exacerbate asymmetries in bargaining power among states. And I think maybe one key to that is reforming the baseline of what states need to sign on to in order to implement reforms. So just very, very briefly, because I think I'm already running out of time. Okay, there we go. So here we are, we have the status quo, your investment treaties with ISDS. And of course, this is my representation of the Framework Convention. Some of the others involved in its development might have a different conception as well. So that's the status quo IAs with ISDS. Step 1, you sign on to this Framework Convention, and this is how you implement your reforms. And in this Framework Convention, the default is that it removes ISDS. So once you sign on to this instrument, there is no investor state dispute settlement. You have a blank slate with respect to dispute settlement. Then you can sign on to optional protocols, one of which could be to opt into a court, or you can have opting into protocols relating to complaints for investment related harms. You can have also protocols relating to exhaustion. So I think the opportunities are endless, but the default could be no ISDS until you then affirmatively opt into it. You can develop other protocols to fill gaps in international investment governance. And you can make access to the court then possible only through this Framework Convention, meaning that, again, you get your default first of ISDS and require this extra step of opting in or not. But that is, again, just one idea, but it's something that we had been thinking about as a way of continuing to submit proposals in this process and that accommodate and advance the broader set of current concerns articulated in the paper and also articulated by so many governments and stakeholders throughout the UNCITRAL process and also external to it. So I will leave it there, but here's a snapshot of the paper and a link to it. And I want to thank the organizers again, and to Kinda and Jane for their work, because I thought it was a really helpful contribution that will help everyone understand what this process is like and think about how to engage in it and shape it. Thanks a lot.
Thank you very much, Liz. Yeah, that's perfect. Okay, thank you very much.
I was just writing some notes and hopefully I can read them. I actually come from a country that is not a big capital exporter, but is a wealthy, affluent country. And We have a government now that has a policy of no ISDS in future agreements. And we have been talking, and I think there is someone from our ministry actually on here. We have been trying to get some engagement with the kind of discussions that led to our government taking that position in the UNCITRAL process. And you know, Pooja was saying, you know, can you get those kind of discussions there? The problem is that the agenda has been so tightly structured that even the countries that do attend and intervene, who have either withdrawn from agreements or who have adopted alternatives, such as the Brazilian alternative based around mediation and no ISDS, or the South African domestic legislation of resolving matters in the domestic courts. There is no space on the agenda for that. And part of the space that there should be for discussing those is about real alternatives. And as Alio said from Senegal, you know, one of the things that should be there is how to strengthen domestic courts. If there's an issue about whether domestic courts can address these questions, let's work out how to invest in strengthening domestic courts rather than trying to reinvigorate international investment tribunals that are fundamentally problematic. And so to get to Tanya's point, I'm a pessimist, Tanya, but we have to try, and this paper is an attempt to try. And it's also an attempt to say, you've been warned that if you don't proceed differently with this process, your process will not have any legitimacy. And hopefully there will be some other voices that will be emboldened by this report, and not only those of South Africa and a small number of others who have been the voices that have spoken to date. But we need also to reinvigorate other processes. We need to get UNCTAD doing what UNCTAD used to do. We need to have the countries that have withdrawn, and Pakistan, one of the most recent. Yes, you certainly can, and you can collaborate with trying to deal with the survivor clause that allows the investors another 15 or 20 years to still take advantage of the agreements. And we did some work several years ago for the on the LDCs, working out where the opportunity was for them to withdraw, because quite a lot of their agreements automatically roll over if they don't withdraw within a certain window of the first term of that investment agreement. And so we need to make sure that we don't get diverted into putting all of the energies into UNCITRAL. UNCITRAL has to be challenged, one, because maybe it might deliver something. And two, if it doesn't deliver, it needs to be challenged. And we also need to ensure that other countries are emboldened and other institutions emboldened to pick up the reins again of some of the discussions that have become a bit diluted. Sorry, that was rather long.
Perfectly fine, Jane. I think give Kinder quickly the floor to add if she would like to do so before maybe for the others to let go. I have next Batch Montes on my list, then Burkhard, Ilge and Abdul El Azizi. So those would be the next. I think the question via the chat by Tom has been answered by Jane already. So Kinder, if you would like to make any addition?
Yeah, thanks, Yvonne. Just some thoughts and recalling like the dynamics of the working group, because Pooja mentioned like why aren't things changing given the kind of cases we see. You see like even within the given the calls of a moratorium on ISDS, given the COVID context and all the threats that potentially emerge, all of this does not trickle down into the working group. Like it's as if the working group operates in a bubble, and these issues don't even get mentioned. And life goes on and work as usual goes on, while there could be like shocks in terms of certain ISDS cases or COVID and ISDS that are happening around. And this requires me to recall as well that at the beginning of the process of the working group, there was not even time allocated for the participating member states to discuss what is the objective of the process. They did not want to deal with that. They actually, and I recall once that there was a mention that we recognize that countries' experience with ISDS is different and their objectives out of this process is different. So then we will try to cater, avoid this major question and cater to everyone and everything and every wish by the member states. So you can see that at some times the working group is not its direction is not clear. It's where it's heading. This is why the formulation of this instrument, which is a menu of options that countries would be given the freedom to opt in whatever they want, is becoming like the way to go in terms of adopting the outcomes of the working group. And this is because that is the only way that they could give, or an impression could be given that there's a coherent outcome coming out of the working group that reflects multilateral conversions. Because if you look closely, actually it will lead to more fragmentation, and it's actually a recognition that there's no convergence at the multilateral level. So, and this is the danger of the process. And I think in terms of possible outcomes and what all of this effort will lead to, I think I would underline what Jane said. What is important is to clarify what is happening at the working group and the reality of the potential outcome, that it is not really a coherent solution, nor a comprehensive and meaningful solution, and that other actors such as civil society, UNCTAD, developing countries have been proposing should remain under serious consideration and under serious work. And for withdrawal, I would just add to what Gus said, as in the 90s, there was collective signing of treaties. There also it could be collective withdrawal from treaties. And maybe Lise want to say more, because CCSI produced a paper on this, and it's a serious idea. And its legality and the legal instrument necessary for such a thing is very pragmatic and possible. So if we just want to recall, the EU member states just had a collective agreement to withdraw or terminate the intra-EU bids or the bilateral investment treaties among themselves after they were declared unlawful by the European Court of Justice. So it is possible, it's very pragmatic, and we can do it if countries can do it if they want.
Thanks, both of you. I have now like to go first, and then I take over after her to Kinder.
Well, if I could just make one comment on Butcher's question regarding the US-Mexico-Canada agreement, leaving aside that, of course, it only affects those three countries in their relationship to each other. The US position has been difficult to follow in the working group 3. And I think we have still to see exactly where they will position themselves in the next 3 or 4 years, because initially they started with a TPP position. And then when the USTR Robert Lighthizer took a very strong anti-ISDS position, they became a bit more muted. And then they didn't actually say a lot, but some of the corporate lobbies from the US who spoke in Vienna meeting, I remember before COVID, said there need to be changes to ISDS. And now we know that the US Trade Representative Catherine Tai has said we still do not support ISDS. And so there's quite a big question here about, even if the others reach an agreed outcome, does the position the US has been taking of no ISDS under the Trump administration and now under the Biden administration and in the USMCA going to inform the position they take in relation to an outcome at UNCITRAL, at Working Group 3? And that actually matters because so many of the bilateral investment treaties are with the US, and so many of the ISDS disputes are with the US. So if they come up with a multilateral instrument that the US says it's not going to sign up to, there's an additional question about, well, what's the point?
Kinder, can you maybe react also on some of the questions and the comment from the person from Morocco?
Yes, well, I don't want to, I would like to hear from Keke and Lee since they raised their hand, but very quickly, thank you, Mr. Al-Azizi, for joining us and taking the floor. It's always very encouraging for us as civil society observers of the process to follow Morocco's positions and point of views, and I honestly appreciated a lot to see your efforts in the last 2 meetings in terms of also putting the highlight again on the cross-cutting issues and the importance to meaningfully address them and not bundle them like all in one category. Anyways, I really appreciate you being here. In regards to your question about invitations, we invited the member states through the secretariats of the G77 in the 3 negotiating capitals, Vienna, Geneva, and New York. I understand for New York, the time is not very conducive. And yeah, so that was our line of invitation besides our colleagues from civil society and academia. So just for you, to clarify. So, but thanks a lot again for being here, and we look forward to staying in touch with you.
Thanks, Kinder. So now it's Keke and then Liz. And Gus, you can already be prepared that I will also ask you again to make a small intervention, if you agree.
Okay. Thank you. I think in terms of my last intervention, I'd like to speak to the issue of how optimistic or pessimistic one is regarding the process at UNCITRAL. And I think, Tanya, much like Jane, I think I'm a pessimist when it comes to the current process and what the anticipated or hopeful outcome may be. And I think it's really difficult being involved in these negotiations and feeling as though one is not being heard. And as I indicated earlier, I think the UNCITRAL process runs the risk of producing middle ground solutions that will fail to address the fundamental flaws of the ISDS system, as highlighted in Kinder and Jane's paper. So I think at best it's going to produce a very weak compromise between the different perspectives on ISDS. And as South Africa, we've continuously signaled the need for holistic and comprehensive reform of both the procedural and substantive issues, and the need to undertake systemic, sustainable, development-oriented reform. And I think South Africa has also stressed the need to locate international investment agreements in the wider context of sustainable development and the need to align national and regional development aspirations. And I think as South Africa, we've also additionally underscored the need for an alternative to ISDS in the form of a more modern and structured dispute settlement process, and one that is better adapted to investment disputes that involve sustainable development, public policy issues, and a range of different stakeholder interests. And I think now we're at a point where I think that countries, especially developing countries, need to look ahead at what the future of the international investment regime could look like, which will obviously require deeper and larger scale changes. I think a multilaterally agreed outcome from the UNCITRAL process will need to be sufficiently ambitious to firstly lay the groundwork for countries, either in bilateral or regional forums, to develop far-reaching reforms, far-reaching than what is actually being discussed in Working Group 3. And developing countries need to signal to UNCITRAL that they are open to innovative reforms, as innovation will help them address some of the most entrenched challenges in the ISDS regime, and also set the tone for future reforms in other forums. So I don't think they're really doing themselves justice. At least some developing countries that don't actively participate in the discussions are not really doing justice to themselves. I think countries really need to engage and really need to ensure that their voices are heard. Thank you.
Liz?
Hi, thanks. Thanks so much. I'll be really brief. One is I just want to echo what KK said, and also what Kinda had said about the interventions of Morocco and valuing them, but would also add how important the interventions of South Africa have been in this process. And then in terms of Tanya's question and this issue of how optimistic or pessimistic to be, if we were to continue on the current trajectory, what I would see is that 10 years down the road, we essentially have a lock-in of and a UN stamp of approval on the same system of dispute settlement that entrenches unequal treatment under the law. And then we would also have a system of forum shopping on steroids, because there's no way there's going to be one system. There's going to be a multiplicity of options from which investors get to choose. So I think there's a real danger with where we are heading. Maybe in terms of solutions, they've been talking about unilateral action on withdrawal or termination, which I think is great to consider. And also that there's a lot of, I think, increasing support around the messaging of that it's a very reasoned decision and in the interest of your population and in sustainable development. So recommend seriously looking at that. But then we also proposed kind of this short-term type of moratoria during the UNCITRAL negotiations, because when the negotiations started, you had all of the states and the EU states talking about how ISDS is fundamentally flawed, not fit for purpose, needs to be systemically overhauled. So why then can their investors continue to use it over the next 10 years to sue states while that process is continuing? So maybe a short-term process, a moratoria on claims. And there could be a longer term, doesn't have to be in the future, but coordinated withdrawal and termination. So I'll just put in the chat some proposals that we had on both of those. And I will probably have to sign off like 2 minutes early. So I just wanted to thank you and say bye. It's been great to see and hear from everybody.
Thank you very much, Liz. So I would now ask Gus if you want to make any further comments. There's still one question left of the chat which I'm going to read out after Gus and before handing for the final words to Kinda and Jane.
Thank you, Yvonne. And very briefly, I just wanted to extend my gratitude and respect to everyone on the call who is following the UNCITRAL process and engaging with it and trying to get as much positive result as is possible in that process. And my contribution here today is a very easy one and a very simple one, is simply that this kind of process is a supplement to the more important goal of getting out. Get out of ISDS as soon as you can, if you're a state. Shouldn't distract from that larger and more important goal. And I want to stress, I don't say this lightly. I don't say it without having thought it through for many years. I wouldn't have said this 15 years ago when I was a PhD student studying ISDS, but I say it now because the risks are too great. Risks of frustrating governmental action to protect organized human society from unacceptable risk of complete collapse worldwide. And I say the same thing to my own government in Canada. I say it to them most of all because they're much more responsible for creating this unfortunately deeply flawed system than most of the countries in the world. So thank you all for your contributions and your patience with these processes. Patience is one of the key words of the pandemic, and I want to thank all of you for your contributions to helping to try to make things a little bit better. That's the best we can each do. Take care.
Thank you very much. And I've seen in the meantime that Jane has kindly responded via the chat to the last question. So I would now give Kinder first the floor, and then Jane going to be the last speaker before I'm closing the session. Kinder.
Thanks a lot, and thanks everyone for joining and staying throughout. It's I would just maybe underline that while this process is frustrating and has been frustrating, it is very important to pay attention to what's happening at UNCITRAL, and it's very important to try to make familiar to circles outside, just like the groups that follow UNCITRAL, make familiar the potential implications of what could come out of UNCITRAL on their work, particularly campaigners and movements and civil society groups that have been working for years and years on advancing the agenda of reform of international investment governance. And unfortunately, just also responding to Andres and adding to what Jane said, unfortunately, like the example of what happened since the mandate of ISDS reform was given to UNCITRAL, and how UNCTAD's role in regards to particularly this issue and its participation in UNCITRAL's meeting, because now no one goes to represent UNCTAD there. This represents fragmentation in the UN system itself. It's very problematic that an organization with a track record of leading the multilateral discussion on international investment reforms for a year, to be bitten, like part of its mandate basically bitten off and given to an organization which really haven't dealt with an issue of such major implications on the public interest and the regulatory and policy issues pertaining to the role of the state, to be given such a role. So we were hoping that UNCITRAL and UNCTAD will cooperate, because you can see UNCITRAL and ICSID cooperating very well, UNCITRAL and other arbitration institutions cooperating very well. So the guardians of the system are cooperating very well with UNCITRAL, but the UN agency that wants to advance further change and advance also the developing country agenda in that regard has been completely absent from this discussion. So there's a major problem there, and I think a problem that indicates a major problem with the UN system as a whole, not only with UNCITRAL. Yeah, I leave it at that. Thanks.
Jane.
Well, firstly, thank you all for sticking around for 2 hours to discuss this. And I think that was our objective in writing this paper, was to reinvigorate the debate around what is happening in UNCITRAL. And as Kinder said, that there have been attempts at intervention. The UN rapporteurs wrote a very powerful statement to Working Group 3, reminding them they were part of the UN system, and that was basically ignored. So hopefully this paper will help to trigger discussions that are not only the kind of really valuable interventions from countries such as South Africa and Morocco during the hearings, during the meetings, and from those civil society who are still going, but that the debate that took place in the Commission over the work plan may also have invigorated it, and many of those same arguments are here. And the next time Working Group 3 has to report to the Commission, there will be a reference point back to these questions and what has changed. I would hope that the academic forum, which Gus left out of frustration and which I remain a part of, but none of what they're doing is anything that I think can actually advance the issues we're talking about, that the academic forum might actually engage with this, and that the floor of Working Group 3 itself will engage with these questions and not simply the micro questions that are currently on the agenda. And so if we achieve any of that, that will have been our goal in writing this report, but we will also be working with many others in the many other fora in which these investment arguments are being contested, and hope that we can produce some just outcomes as a result.
Thank you very much. And in order to be possible to close the meeting on time, I just thank all of you for having stayed throughout the session. Stay in touch with us if you have any further questions. Either get engaged or stay engaged in the process, and of course, read the publication and share it with others. Thank you all very, very much, and have a nice evening, afternoon. Good night, Jane, and yeah, see you all somehow virtually or in person. Bye-bye.